Skilton, you may proceed.
Good afternoon. May it please the court, counsel. My name is Thad Cosgrove. I, along with my co-counsel David Skilton, are appearing on behalf of the Appellant 4-H Foundation. This case comes before the court upon the trial court's denial of the 4-H's motion for summary judgment and the granting of the Arboretum's motion for summary judgment on a declaratory action, finding that the lease of agricultural land for a term in excess of 20 years did not violate Article 1, Section 24 of the Iowa Constitution, which states, in essence, no lease of agricultural land exceeding 20 years is valid. 4-H owns a 300-acre farm in rural Boone County, zoned agricultural, leased to the Arboretum. The lease is made up of two documents, a memorandum of understanding and a cash rent lease. The documents constitute a lease of the farm to the Arboretum for the dual purpose of expanding their then existing 40-acre tract to include the 4-H farm, with the condition for payment of rent to the 4-H for crop acres. The lease acknowledges that the farm contains both tillable and non-tillable acres. It refers to leasing of tillable cropland. It sets forth a detailed equation to determine the accrual net farm income per tillable acre. It sets forth the Arboretum's agreement to pay annual cash rent to the 4-H for the tillable acres. Requires the 4-H to keep records to determine the compensation. It's for a term of 99 years for rent of $1 plus rent for the tillable acres. It's the 4-H's position that the trial court erred in finding that the lease is not voided by the terms of Article 1, Section 24. The trial court held that the lease was strictly and purely for non-agricultural purpose and not entitled to the protection of the Iowa Constitution. In doing so, it relied on this court's ruling in Howard versus Schickenberg Construction, which involved the leasing of a farm for the sole purpose of mining, finding that the leasing of the 4-H property to the Arboretum was solely for a non-agricultural purpose, such as mining. As noted in footnote 2 in Howard, in that case, it's distinguishable. The landlord there never challenged that the lease had an agricultural component, despite the fact that part of the land continued to be farmed. This is not a case of a lease of agricultural land that was solely...
What kind of test do you propose? Do you propose a primary purpose, substantial use agriculturally? Do you propose we can sever the agriculture from non-agriculture, or is an arboretum really an agricultural thing? I mean, well, I asked you a lot of questions, but I mean, how do you propose to do this?
The two that I remember, I think the Arboretum is an agricultural thing. And two, this court has, on different occasions, held in these dual purpose scenarios that you look to, does the land have an agricultural purpose? In Mitchell, I believe.
So if maybe 2 acres had an agricultural purpose and 158 didn't have agricultural purpose, it's still an agricultural purpose lease?
It certainly could be. In Mitchell, there was 17 acres of pasture and 1 horse, and found it was an agricultural purpose. In Qualley, it was the same thing. It said, well, part of it was agricultural land. It had an agricultural purpose. It's entitled to the statutory protections granted agricultural land. That was a farm mediation case. We said, well, you had to give them the mediation. They didn't do it.
Let's, in this case, for the land that they are actually using, the only agricultural purpose of that land that you can identify is the fact that there's an arboretum, right?
They actually have control over all of the ground, Justice. So I don't see where where you can say they're only using the land that the timber is specifically on. They lease the whole farm. So they're using the whole farm. And when they leased it, they did so knowing that they were going to be paying for the tillable acres. And that cannot be denied.
They subleased the tillable acres, is that what they've done?
Excuse me, Justice?
They subleased it, or are they farming it themselves?
They farmed it themselves. Hertz Management was manager of the farm, and there is some CRP program since 2010. As I stated earlier, this is not solely for agricultural purposes. We've talked about tillable acres. We talked about that the Arboretum agrees to pay the additional rent, and the lease sets forth a method for computation the tillable acres, including diverted CRP acres, and it requires.
Could you
Yes.
elaborate on why an arboretum is agricultural land?
There are some code sections, Judge, that state that forestry and timber is considered agricultural lands.
Well, this isn't quite forestry and timber in the sense of producing product for sale, I take it, or do I have it wrong?
Could you?
Yeah, I mean, if you had forests for purposes of harvesting lumber, or forests that you used even for grazing purposes or whatever, that might be one thing. That might be an agricultural use. I mean, grazing in a forest strikes me as clearly agricultural use. And maybe even severing timber might be considered an agricultural use. But an arboretum strikes me as potentially a different kind of use.
I agree with you. If this was an arboretum standing alone, but it's not an arboretum standing alone. It is dual purpose. An arboretum is a tree museum, for lack of a better word, I guess. But that's not what happened here. We have an arboretum not standing alone. We have an arboretum using tillable acres, entering into a lease,
Now,
paying for those acres.
let me see if the way I understand the tillable acre arrangement is there's 30 or so tillable acres, something like that, or 40 or so tillable acres, and they, in essence, have an annual option to use some of those tillable acres. Is that essentially how it works?
There are, I believe, between 50 and 60 tillable
Okay.
acres. They had an option to use it. They've turned it in, I think, grasses, and they've optioned
Right. The
maybe
part
70
that they actually exercise the option to use, they use it for just leaving prairie grasses and for parking lot, right?
I believe that's correct.
So your argument as to the tillable acres would be if they have an option to use it, even if they're not actually using it, then it's that part that they're not presently using is used for an agricultural purpose. That's enough to bring them within the provision, right?
Correct, Justice.
Okay.
Once the lease is shown to be not solely for an agricultural purpose, you must determine three things to invoke the constitutional provision. First, you must establish the existence of the lease. That's undisputed. Second, you must establish that the lease term exceeds 20 years. That's undisputed. The third is you must establish if it's agricultural lands. If all three are established, the lease is void as a matter of law. What constitutes agricultural lands? The appellate court has defined agricultural lands for the purposes of the Constitution, but as noted in Howard, the appellate courts look to the Iowa statutory scheme to define agricultural lands. Code sections referenced by this court in Howard establish that this farm does include agricultural lands. A review of those code sections and others appear at page 16 through 19 of the 4-H's brief. Those code sections state that agricultural land is land suitable for farming, and farming means cultivation of land for the production of, among other things, crops, use of land
Well,
for
I think
grazing.
the definitions that I've been looking at there, they're sort of a mixed bag, and so you've got some inconsistencies even within those code sections, the way that I read them. Some of them talk about farming not including the production of timber, and other ones that do include the production of timber, forest product. Other ones seem to require a good faith used for agricultural or horticultural purposes. So what, obviously you want the definition that's most broad to define this land that we're talking about here, but I'm not sure that with all this mix of statutory provisions, whether you really get there or not, or what are we supposed to rely upon?
Well, I agree with you, Judge. There are some that say timber is farming, and some, and I think there's two different ones, and one that says timber is not, one says beekeeping is farming. But something that is consistent is land that's suitable for crops and land used for grazing or that can be used for the production of livestock. That clearly is established here. It is undisputed.
Counsel, let me just interrupt on that point. The land is clearly suitable for agricultural purposes, but is the lease used for agricultural purposes?
The lease itself calls for a dual purpose, arboretum and agricultural purposes. Calls for paying rent on tillable ground.
Well, but didn't the parties view this as an arboretum? Isn't that what brought the parties together?
I think that the parties, I think it's hard to look at it that way, because if you do, you're taking the one purpose clause out of from the lease to the detriment of all other clauses of the lease. It says the purpose is an arboretum. However, we are going to farm this land and pay you for the tillable
Well, what if we,
acres.
I mean, maybe neither party asked for this, but is there a severance issue? The balance of land is used for arboretum purposes. Maybe the equitable thing to do, we might consider, is saying, well, with respect to the 40, 50, 60 acres, that's severed from the lease. And if the Arboretum wants to pay the same consideration for a lesser piece of property, they ought to be able to choose to do that.
That issue has never come up.
Here's the thing, you know, reading this cash rent 99-year lease, all right, there's the land with the trees that's the $1 with the $1 rental, and we can argue about whether that's an agricultural use. Then there's this tillable cropland, but it sounds like just reading the lease itself that it's not going to be used for crop purposes to the extent it's rented by the Arboretum, because it says the compensation will be based on annual farm income earned by the 4-H's tillable land, and the remaining 4-H tillable land, which makes it sound like they're gonna pay some kind of an opportunity cost type rent, because they're not going to be using it for that purpose. So if none of the land is contemplated to be used for agricultural purposes and never has been used for agricultural purposes, how do we get to the constitutional
The land has been used for agricultural purposes. It's been used for agricultural purposes since its outset. Hertz Farm Management has been up until 2010 managing all tillable acres. There are checks to the 4-H for rent. So there were agricultural uses of this property. In addition, of course, to the Arboretum. That makes
The
it
land
different.
that they actually have under lease, that the Arboretum has under lease, they're using for agricultural purposes, or are they just, or is it land they have an option to lease and they haven't leased? That's what I'm trying to get straight.
There's CRP ground there right now, Judge, and that is an agricultural purpose by statute.
All right, and that's land that they've exercised the option on, in effect, to lease.
A
Is that
portion
right?
of it, they have. They've exercised the option. That's 7 acres,
And-
whatever.
But that 7 acres, is that CRP land, or is that just?
No, that's
Okay.
natural prairie grasses.
So
actually.
that's the point, that the land they're actually exercising the option to lease is not being used for CRP or crop production, right?
No, but it's suitable
Okay.
for both.
Right.
And that
Well,
is-
I
and that's
understand.
what's- and that's-
I
and
think-
that's what's
I
important.
think probably 95% of the land including probably outside here, is suitable for crop production, right?
I don't know if I'd agree with that, but it's suitable for raising crop, and it's suitable for livestock production and grazing, including the timbered areas, as we would normally take rural zone, rural ground. Yes, I suppose we could feed sheep on the grass here. Don't know how the city's gonna feel about it, but I don't think that's what was meant. I don't want to run out of time to talk about the summary judgment issue. And
You may sum up on that issue.
may I? Thank you, Judge. Regarding summary judgment, in the event the court finds that the denial of the 4-H summary judgment was inappropriate, it is 4-H's position that there exists a genuine issue of material fact precluding the granting of the Arboretum's motion for summary judgment. The court, in granting the summary judgment, held that because the court finds that the cash rent lease was not a lease of agricultural land, it holds that the cash rent lease is valid, granting the summary judgment. However, the court granted it, ignoring the genuine issues of material fact existed, and that the land was not solely used for agricultural purposes. Sharon Chisholm, the farm manager of the subject property, filed an affidavit which stated that the property in question contained approximately 50 acres, more or less, of tillable ground, that Hertz Management had managed the tillable acres for over 30 years, that all but 3 of those acres were placed in the CRP program in 2010, but prior to that time, to be enrolled in the CRP program, those acres were farmed as row crop, and find that the balance of the 4-H contained timberland, portions of which were suitable for grazing. Robert Hibbs, a forester, filed an affidavit showing at least 59 acres are open grass fields, obviously suitable for grazing and or row crop. There were aerial photographs presented at the summary judgment hearing from the FSA office showing that it contained tillable land as well as ground suitable for grazing, including the timbered areas. The affidavits, the photographs, along with the contents of the lease itself, create a genuine issue of material fact regarding if the lease was for the sole purpose of agricultural land and suitable for farming. I believe that there's a genuine issue of material fact regarding whether the lease was for the sole purpose of an arboretum and the existence of agricultural lands, and that summary judgment at this stage was inappropriate. Thank you for the additional time, Justice.
Thank you, Mr. Cosgrove.
May it please the court. Thank you, Chief Justice. I think this is the rare case that there might be more issues regarding factual, not disputes of fact, but confusion over the facts that are in the record as opposed to confusion about the law. So, Justice Appel, I want to start kind of with your question about why it's not okay, why we don't just split this and why this has never really been raised. And I was not trial counsel, was appellate counsel in this case, and my first thinking perhaps was the same as yours upon reading the 4-H Foundation's brief. But the reason that it's never been raised and the reason why it's not an issue is because the Arboretum is not farming any of this land. And so there is no reason for this split. There is just a confusion about what that portion of the lease that allows for the leasing of tillable acres means and what the formula means. As Justice Mansfield said, really it is simply an opportunity cost provision. And it says, look, and if you go back actually to the Memorandum of Understanding, it talks about how the 4-H Foundation will continue to farm the land that's always been farmed until such a time as the Arboretum is ready to take it over and develop it for the Arboretum, not to farm it. And so what you see in the lease then, come 1980, is essentially fulfillment of that idea, which is the lease provision for the tillable land will start once the Arboretum exercises the option to take that land for Arboretum purposes. And of course, they're gonna have to pay more for that portion of the land because that has been profitable for the 4-H Foundation. So what are they going to pay? Well, they're going to pay what the profit would have been. And so that even is different from, for example, a cash rent lease where a farmer rents from the owner of the land, because the price of that lease assumes that
I'm sorry to interrupt you. I want to get into, I guess, the very specific facts. You know, I think I have a pretty good understanding of it, but we have the 250 acres, which is clearly timberland, and we can argue about whether it's capable of grazing and those kinds of things. But tell me what's going on with the other 50 acres. Now, somebody's getting CRP payments on this, and they have since 2010. And so how many acres is in CRP of that remaining 50?
So if you go to the appendix, I believe it's at page 123, there's a statement of facts that lays out kind of all the elements, all the different boxes of this land. And there's a 250 that has been the Arboretum and always the Arboretum. There's a small portion that the Arboretum has exercised its option on that has made into prairie grass, and there's a small portion that has exercised its option. Yes, I can. So, exactly. So we have 250 acres that are the Arboretum. We have 3 acres that are being used for the parking lot by the Arboretum. That's the 3 acres of the tillable ground. We have 4.1 acres that the Arboretum has exercised its option that has turned into prairie grass. Then there are 3 acres that are actively being farmed by the 4-H Foundation or some tenant of the 4-H Foundation. And then the remaining is in CRP, in which the Arboretum has not exercised its option, and either the 4-H Foundation or some group that it has leased that land out to is getting the CRP. The Arboretum gets no money for farming or for CRP for any of this land. And and we heard before that Hertz Management manages this. It manages that land for the 4-H Foundation. Sharon Chisholm's affidavit makes that clear. And what I told you, Justice Zager, about the facts that we laid out, they're all laid out on page 123 of the appendix in the statement of facts. And then there's also a map on page 134 and 35 that go with it, because all these different points of the property have been designated A, B, C, D, E, and those are mapped out there. So really at bottom, that's the confusion. The Arboretum does not use any of this land for agricultural purposes. It does not get any CRP funds for this. That is still in the 4-H possession.
Isn't an Arboretum farm purpose or agricultural purpose?
Well, it's not what we normally think of. It's not what we think of as farming or as agriculture. And actually, so if you look at Howard actually references, and 4-H Foundation makes this point about what is suitable farm, or what is farming. And they reference code section 9H.1. And if you look there, it's essentially growing crops or using it for livestock. And in this case, neither of those things happen. Now, even if, as was raised, and somehow a timber production company, if that was somehow farming, that's not what this is either. This is literally a tree museum, an area in which trees are grown so they can be studied and looked at. There's no harvesting of the trees, at least not in the sense of it's meant to sell them. Perhaps some of them are taken down because of disease or other things, but there is no farming of the trees. And we are also an agricultural state, meaning a farming state, meaning a crop state. We are not a forestry state. So when they put this provision in the Constitution, of course, we had hardly any timber, maybe by the riverbeds, and that's it. Otherwise, we're all prairie grass. So the idea...
We also had a lot of apple production, which was a lot of trees. We had more apple production than was in Washington back in the old days.
And you make a good point, Justice Wiggins, that apple production would be for food, right? So it's the trees are growing food that are then harvested. Here, there's nothing that is harvested. There's no food product. There's no livestock that's grazing on the land.
What about the argument that they make that you have, in effect, an option every year over taking possession of land that's currently being used as farmland or as CRP land?
Well, the term lease of that option, I guess, would start when we would exercise the option and when we would make it, and then the purpose for the lease would be for non-agricultural purposes. And if you actually look at Howard, the other the lessor actually used part of that land. All the land was leased to the mining company. The lessor would use portions of the topsoil that where the mining company was not actively mining. So it's very similar to here. The Arboretum is not exercising its option in this case for the cropland, and so the lessor can use it as such time as we take it over. If we were to take it over and use it for agricultural purposes, that would be a different story. But again, as I pointed out, there cannot be an agricultural purpose in this lease because the formula that forces us to pay rent would make it so that we could not make a profit on that. So of course, the Arboretum's purpose is not for farming, it's for the Arboretum. But this lease simply does not in such express terms, but as a practical matter, does not allow for any agricultural activity on it at all.
What's the purpose of the constitutional limitation on the duration of leases of agricultural land?
So of course, if we go back, we know we have a little bit of history in that from the convention, which is subsuming the history from New York. And of course, this provision was meant to prevent the, quote, anti-rent difficulties that New York faced, and that was the feudal-like rents that Alexander Hamilton created, under which people rented the land, leased the land, essentially an incomplete sale is what he called it, for a long period of time, in which they would have to give the Dutch land settler some of their crop every year, some of their hours every year, and eventually they fell short on their rent, were forced to leave, and there was violence surrounding that. So really, the whole purpose surrounding this provision is for oppression of lessees. We are, of course, the lessee. The lessor is claiming to be oppressed. The constitutional provision, of course, is not singled out to protect just lessees or to apply in that context. But if you take a step back, that's obviously what it was meant to do. So this idea that we are not paying enough rent, and really that undergirds this whole case, right, is not relevant at all in the constitutional analysis. And
It also promotes alienation of farmland, it seems to me. And does the cloud of your lease impair the alienation of the land?
Well, of farmland, but this court has already held that it's just not, it cannot be that it's suitable for farmland, because as Justice Mansfield said, the whole state, I think, is suitable for farmland, more or less. It has to, the purpose of the lease, it has to be farmland, suitable, number one, and two, the lease has to be for farming purposes, and that is not the case here.
But shouldn't, I mean, you know, Iowa is a state that favors alienation of land, and shouldn't anything that prevents alienation of land be strictly construed?
No, I don't think so. I mean, this is essentially a sale. I mean, you have a lease of a long period of time, and there's nothing wrong with the long sale. It was for alienation of agricultural land that was being used for that purpose. Again, it was going back to New York and for the difficulties that were faced with farmers. I think if you would change the law and overrule Howard, because Howard expressly says the opposite. I mean, we would have, that would open the door to a lot of leases. For example, what about colleges that have 99-year lease on buildings? The federal government has 99-year lease on land that surely is suitable for agricultural purposes, and that would throw those leases open. There is no reason, I think, no reason in the history of the constitutional provision, and no rational reason for this either. And I think actually, if you know, New York has taken this provision out of its constitution because it's antiquated. I think when you have a provision that has outlasted its useful life, which I think this one has, you simply don't want to go back and interpret it in a much more restrictive manner that wasn't meant from the very beginning.
What do you believe to be the definition of agricultural land? Under the code, as excuse me, it is in different contexts, but what are you telling us we should rely upon to be the definition of agricultural land as found in the code?
I think 9H1 does it sufficiently, and that comes from the historical text of this, which the New York leases were for agricultural purposes, meaning cattle, livestock, and for crop raising. And then if you go look at the definition in 9H, it also happens to align with the dictionary definition of the term agriculture and of farming as well. So I see no reason to go beyond that, and I see no other source besides the few other provisions that talk about timber.
Do you have to farm for profit, or does hobby farming fit agricultural land?
I think that you make a good point. I think it depends upon the whole lease. So there are cases out there, for example, where there has been there's one case from North Dakota where they had or South Dakota where they had a gun club. And they grew prairie grass around the gun club, they grew alfalfa, and they did cut it down every now and then, and they sold it. The purpose wasn't for farming, it was just to maintain the land for the gun club. And the court there said that that was just merely incidental to the real purpose of the lease, which was for the gun club. And then there's another case coming out of the Dakotas too, which the real purpose of the lease, again, was for a radio tower. There was some incidental farming just by the happenstance that it's fertile ground. You have alfalfa, you have weeds that grow, you cut them down, you sell them for hay. And so really what you have to do is look at what the purpose of the lease is. So if there's some incidental farming, I don't believe the constitutional provision covers it. So if Simpson College were to create a scientific study, somewhere out in a farm field, and they would have a small portion of corn that was the size of this room, that they would study the effects of pesticides when it's sprayed on them. Yes, technically they're growing corn, but the purpose of the lease would be for the facility itself, and therefore the constitutional provision wouldn't apply. So it's really, what is the purpose of this lease?
And I have one more question then. If we rely upon your definition of agricultural land as found in 9H, the definition provided there is that it's suitable for use in farming. So is it the position then of the Arboretum, of course, is that none of this land that is subject to this lease is suitable for farming?
No, I should be very specific what I'm saying. So Howard already held that suitability isn't enough. But then there's also the issue of what is farming. And I think that's where you can go look at 9H1, is what is farming. And we concede that this land is suitable for farming because corn can be grown on it, cattle can graze on some of it, but it's not being used for farming, and the purpose of the lease is not for farming. And that gets to the point of whether an arboretum itself, whether a tree museum is an agricultural purpose. If you would like, I could briefly touch on the counterclaim. I think the main issue there is we are still not even clear what exactly their breach is. I think it's important to know the history of what happened here, which is that in 2005, the parties did have a meeting. They talked about the purpose of the lease, summer of 2004. There's a letter in the record talking about that. Nothing happened. They said we should meet in the next 5 years. 2009 went by. Nobody said anything. 2013, out of nowhere, there's no evidence in the record of any request by the Arboretum to talk about the lease. Out of nowhere, the 4-H Foundation terminates the lease. There was a letter sent by a board member of the Arboretum, Kathy Law, to the 4-H Foundation where she just said, there is no way in which you can terminate this lease. I've heard a lot of things about why you believe that you can terminate it. None of those are true. There has never been a breach of this lease. There's nothing in the record that comes from 5-year provision that the 4-H Foundation said, let's talk about it, and that the Arboretum said we refuse to do so. So on that basis alone, that there simply is no breach, that issue can be affirmed. And we ask that you affirm the district court's order. Thank you.
Thank you as well, counsel. And now Mr. Skilton or Mr. Cosgrove, who's gonna, all right, you're gonna return, all right.
Thank you, Justice. The Arboretum didn't deny that there was a lease, didn't deny it exceeds 20 years, didn't contest the Iowa statutory scheme defines agricultural land as land suitable for farming, doesn't deny the definition that farming includes tillable and grazing acres for livestock. Everyone agrees that that's farming. Does not deny that portions of the farm is suitable for farming.
Don't we have to overrule some of our old cases in order to get where you want to go?
No, I don't think you really do. Here's why. Here's why Howard is the one I'm thinking of, Justice, is because it is inapplicable because the way it was challenged. The landlord never challenged that it had a agricultural purpose, or that was a part of the lease between it and Howard. It was solely a mining lease. The landlord in this litigation, unlike Howard, does not concede that the land in question is being leased purely for non-agricultural purposes. At least documents in this case set forth that the leasing of the farm was dual purpose. That was not the case in Howard. The lease documents here establish the planting of tillable crops. Paragraph 7 clearly of the lease talks about paying rent for tillable ground, that rent being based upon the 4-H's rent it received on other ground next to it on
that
campus.
It is,
Yeah.
go,
Just gonna say, I mean, I can, my daughter can agree to pay her landlord based on the CME soybean price every month. That doesn't make it an agricultural lease, right? I mean, that's just a method of payment, right?
It shows that there was a agricultural component, agricultural lease component, that this just wasn't a completely an arboretum, solely an arboretum. And as for their option, the 30 years is gone and the option is still there. We still have tillable acres.
doesn't it show just the opposite, though? That when you're not gonna use it for agricultural purposes, you have to pay us a amount of rent equal to what we would have had if it was agricultural purposes. I mean, I think it cuts both ways, your argument.
I think, I'm sorry. Could you repeat that, Justice? I'm sorry.
Well, it shows to me that you are intending that when they take it out of agricultural production, the rent's based on what you would have received if it was in agricultural production, not that they were going to use it for any agricultural uses.
No, I don't think that's what it says. I think once they take it out of agricultural production to be used in the Arboretum, it is the Arboretum and is no longer could be leased. This court let me strike that. The Arboretum appears to argue that the constitutional provision, although it gives lip service, is solely for the protection of tenants. And that's contrary to what this court recently held in Ganson versus Ganson. There, this court ruled that the Constitution does not distinguish between the interests of the landlords and the tenants. It also appears to advance the larger purpose of promoting the alienation of agricultural lands by not excluding landlords from its terms. You held that because one of the parties, either the landlord or the tenant, may be locked into an agricultural lease for more than 20 years, that Article 1, Section 24 is offended if that contingency occurs, and the lease is void. This is not an instance where it is a lease for solely non-agricultural purposes. That has been established. That has been made obvious by the terms of the lease and by itself and otherwise. This is a case involving the leasing of a farm, a portion of which clearly constituted agricultural land. It is suitable for farming, it is suitable for raising crop, it is suitable for raising livestock, it's suitable for grazing. Depending on the statutory scheme, it's certainly suitable for timber and timber production. For those reasons expressed, we would ask the court to grant the appeal, overturn the district court's ruling, reversing the denial of the 4-H's summary judgment, reversing the declaratory judgment, summary judgment for genuine issues of fact, and remand for trial on all issues. As for the contract issue, we'll let the briefs speak for themselves. Thank you, Justices.
Thank you as well, Counsel. The case of Iowa Arboretum and Iowa 4-H Foundation is now then submitted, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.